So, a lot of fancy legal issues here. What this all boils down to is the New York Times thinking they have special rights which allow them to subvert the rules the rest of us have to follow, even news organizations, and especially Project Veritas in court. Let's see what it all means. We're going to take you through it. So back in November 2021, the New York Times published memos written between Project Veritas and our lawyers in the very defamation case we have against the New York Times. On December 24th, 2021, Christmas Eve, Justice Charles Wood of the New York Supreme Court ordered the Times, in this order, to give us our confidential legal memos back, calling the Times reporting, quote, hit and run journalism, that's on page 25, and a shot across the bow of their litigation adversary that, quote, cries out for the court intervention to protect the integrity of the judicial process, page 26. Now, remember, this is about attorney-client privilege documents, which is a sacrosanct and very important thing, and lawyers who represent us in this very lawsuit. Now the New York Times is appealing the New York Supreme Court's Christmas Eve order. The New York Times is now arguing that order violates the First Amendment, calling the order, quote, an extraordinary prior restraint. The New York Times also arguing they get to publish our attorney memos, quote, even if the Times acted improperly, unquote, from page 12. The Veritas lawyers writing that the only thing extraordinary about this dispute is the conduct of the New York Times. Our lawyers sum it up this way from our appellate brief. The true gravamen of the Times argument is that as a media outlet, it is entitled to special treatment, and that it should not be subject to the same rules of practice and conduct that any other litigant appearing before the New York Supreme Court is held to. In the ruling, the New York Supreme Court ordered the Times, number one, to immediately turn over Project Veritas counsel all physical copies of the subject legal memoranda. Number two, immediately delete, destroy copies of the memoranda and remove such documents from the internet. Number three, to retrieve copies of the legal memoranda provided to a third party. Number four, not use the legal memoranda in this action, meaning our lawsuit, our defamation case, quote, for any purposes whatsoever. And number five, do not show, transmit, or disseminate the attorney-client memoranda in any manner to any persons absent written order of this court. Now, in this appeal, the New York Times argues the New York Supreme Court's order is an extraordinary prior restraint on the reporting. The term given when the government attempts to take actions to prevent speech, the New York Times admits this, acknowledged that a, quote, classic prior restraint on speech is one which forbids speech in advance of its actual expression. That is from the appellate brief before the Appellate Division. Problem with that, the court's order did nothing to forbid the Times' speech in advance of its actual expression. The article was already published. In fact, it remains on the internet to this day. Listen, the government can't shut down newspapers. The seminal case on this is New York Times versus United States, a 1971 case which became known as the Pentagon Papers case, in which the government attempted to prevent the New York Times and the Washington Post from publishing classified documents leaked to them about the government's actions in Vietnam. Notably, the Times and the Post were fighting for the right to publish articles which had not yet been published about information which had not yet been shown to the public. Hence why the U.S. Supreme Court ruled it was an unconstitutional prior restraint. This is not the Pentagon Papers. The Times already did publish our memos. They already published their article because they're the New York Times and rules don't apply to them.
I think it's funny too.
So our lawyers respond to the New York Times' appellate brief with an appellate brief of our own. The New York Times makes a Herculean effort to turn this simple discovery dispute into a lofty constitutional case of prior restraint. Pentagon Papers, right? But the Times' arguments fail for two fundamental reasons. First, the New York Supreme Court's order is by definition not a prior restraint because it was issued only after the New York Times published the privileged documents. The order did not prophylactically prevent the New York Times from writing about Project Veritas, and Lord knows they're obsessed with us because they keep publishing front page stories. This was narrowly tailored to prohibit republication of the same attorney-client memos that the Times conceded were privileged and obtained by irregular means, already had been published on its website. Second, This order by the judge is not a prior restraint because it is a content-neutral application of a law of general applicability, the civil practice laws and rules. The order has everything to do with the Times' conduct as a litigant before a Supreme Court and was entirely incidental to the fact that the Times also happens to publish a newspaper. Now, in fact, unlike a real prior restraint, the New York Times is expressly allowed to report on Project Veritas. Justice Wood pointed that out in his order, saying, quote, "The Times is perfectly free to investigate, uncover, research, interview, photograph, record, report, publish, opine, expose, or ignore whatever aspects of Veritas its editors in their discretion deem newsworthy without utilizing Project Veritas's attorney-client privileged materials in the very lawsuit that we are litigating with the New York Times." Since the order was issued, the Times has published 10 different articles, op-eds, and letters reporting on Project Veritas, including this gem from the top of their opinion page, a dangerous court ruling with the quote, "No court should be able to tell the Times or any other news organization, or for that matter, Project Veritas, how to conduct its reporting." I guess the New York Times, as they're calling us a news organization, with, quote, "reporters." Isn't that rich? We know that Mike Schmidt at the New York Times doesn't like to call us journalists, like to call us operatives.
You didn't like it when I said operative versus journalist, right?
You know, the guy with the notepad who has nothing in his refrigerator.
You know, I am single and I live by myself. I have no other commitments and I work and that's what I do. I don't even have food in my apartment.
Now, the Times tries to justify this litigation misconduct by claiming the memos are not part of this lawsuit and are in fact irrelevant to it. This from their brief. The lower court's finding that the Times obtained the memoranda by irregular means also rests on the erroneous premise that the memoranda have some relevance to the claims or defenses in the underlying defamation action. They do not. Despite arguing that the memos are irrelevant to our lawsuit against them, the Times concedes their November 11th article disclosed the existence of this pending lawsuit by Project Veritas against the Times, and that the memos published by the Times were authored by Ben Barr, quote, one of the lawyers representing Project Veritas in this defamation action, who helped hand the New York Times its historic motion to dismiss defeat. But the Times goes further. As our lawyer points out, the Times story also specifically referenced the ongoing litigation between the Times and Veritas and stated that the privileged memoranda gives the Times new insight into the workings of Project Veritas and how it uses tactics outside of mainstream reporting techniques. In moving to dismiss Veritas's defamation complaint, the Times asserted as a defense that Veritas is a, quote, libel-proof plaintiff because of its history of using sting operations and entrapment tactics. They actually cited Wikipedia in their legal motions regarding that argument.
Your lawyer citing Wikipedia. Yes. I think it's funny too. So you're laughing at your lawyers.
I think Project Veritas.
Your lawyers are citing
I think
Wikipedia.
Project Veritas is hilarious.
Now, these are the same journalistic tactics discussed in the legal memos. The Times' published description of the memoranda echoed the arguments the Times made in a motion to dismiss the defamation action. So in sum, the Supreme Court concluded correctly that the Times' own representations unquestionably demonstrated concomitant prejudice to Veritas. Defamation, in this case, is not like the Pentagon Papers. Now, as much as the Times would love to, the Times can't go back in time and make this post-publication order a pre-publication restraint, as they would have to do in order for their argument to make any actual sense. This case is simply about rules that apply to everyone. And for now, this matter is pending in the New York Supreme Court's Appellate Division, who is tasked with deciding whether the New York Times will be held to the same standard that any other news organization is held to. Stay tuned.